Okay, good afternoon, everyone. My name is Joshua from Indonesian Society of International Law, and I'm delighted to welcome every one of you here on our today's webinar, another session of ISIL webinar. And as we know, is that Sundays are always a good days for to chill and relax with a cup of coffee and Netflix. But we do appreciate you have taken your time to tune in and have a good taste on what Sunday should look like. So thank you, everyone. And I just took a quick look on our attendees list for today's webinar, and we have quite diverse of representations from law school and law communities in Indonesia. And today we are so happy to have Bahana Azkia, as always, an associate from King and Spalding Singapore, a former GSUP competitors, and one of the GSUP national round judges. So welcome Bahana to today's webinar. And she will share us about one of the important things, especially for all of you guys who are the teams for the upcoming 2021 GSUP competitions, which is about the memorial writing from a judge perspectives. And I also would like to welcome our friend here, Yogi Bratajaya. He's from Pelajaran Universities, and he's the former GSUP 2019 and 2022 competitors. So without any further ado, let me give the floor to Yogi. Please, Yogi.
Yes. Thank you very much for the warm welcome. I am very fortunate and I'm very happy to be here alongside Bahana Askia. Without further ado, shall we start the presentation?
Yes, please go ahead. Thank you.
Thank you.
Okay, thank you, Yogi, for sharing the presentation. Oh, I see the font has actually kind of changed. All right, that's fine. Anyway, thank you so much first of all, to the Indonesian Society of International Law for organizing this event. I know in the past they've always tried to hold these kind of events to help new participants and also, other participants to the GSUP moot to gain the necessary training before they enter into the moot. And I do wish that had these kind of trainings existed when I was a law student myself, I think they would be very helpful. So thank you to ISIL, and also thank you for taking your time today. I hope it will be useful what you take from today's session. So let's just start. If you can move to the next slide, please. So there's two goals primarily that I want to achieve from today's webinar. There's quite a fair things that I would like to cover with you all. I've asked the committee to save the questions as a result at a later stage so that I can properly go through the presentation slides. So the two things that I would like to cover, number one is I would like you to understand what boxes must be ticked by a memorial in the GSUP moot. And when I say boxes, I mean the elements in the scoring sheet that the participants should achieve, or target to fulfill. And the second thing is, even if you decide not to participate in the GSUP moot after today's webinar, I hope nevertheless you will still gain some usefulness, which is the meaning and elements of exceptional legal writing generally. And that's because I think it's a key skill for any law student to have, knowing that you have the ability to persuade in written form and make sure that your words literally transcend through the pages, whether you're going to end up working as a lawyer or working in-house. Basically, the art of good legal writing or the art of writing is just communication in paper form. And for some people, that's not as natural. Some people find it easier to speak. Some people, myself included, find it easier to write their thoughts. So yes, I hope you even if you don't participate in the moot, you still have some usefulness that you will take from this session. Moving on to the next slide, please. So first of all, what is a memorial? I asked this question first of all before we begin because not a lot of law students who first start off the Jessup moot understand what is a memorial, what creature is it. I write there, something must already be understood or else thinking is impossible. I myself had asked that question when I was a student. I asked it of one of my friends who had joined a moot. In my head, if you can turn on to the next slide, a memorial was a makalah or an essay. I just really didn't know what it was. And obviously a memorial is not any of the things that you see on the screen. It's not a research paper, it's not an opinion paper, it's not an essay, it's not a thesis. What it is, next slide. A memorial is a written submission or a pleading in written form. It contains the legal arguments of a party to a dispute, specifically in the Jessup context, for consideration by the International Court of Justice. It could also, if you are working as a lawyer, it's the legal arguments that you have for consideration by the judge or consideration by the arbitral tribunal. And if you're not talking about a memorial, good legal writing, you'd still need to pay attention to who is the audience. But for our purposes, a memorial is a written submission or a pleading. I will pause here and just kind of explain a little bit more on legal arguments. Means it contains arguments which are based on the law. What law? In the Jessup moot, it means public international law. Why also the memorial plays such a key role in the Jessup moot is because not only do you get awards for writing the best memorial, but also when the team has a tie with the other team in the oral stage, the memorial is usually used to determine the tiebreaker. They go to see the scores, which team has the higher score in the memorial, and that team advances. So the memorial plays an important role in the Jessup moot, and which is why, as much as possible, you should try your best to write a really good memorial. Next slide, please. There are certain materials that I feel would be useful to consider reading before you begin. The first one, look into past best memorials in the Jessup, and you can do this by going through the ILSA website. I understand from the committee earlier that there's been a previous session by Atalia where she discussed where you can gain these sources, on past memorials. So if you do go through the website, it will tell you, from 2019, 2018, and all the other past Jessup years, which are considered the best memorials in that year. For me, it would be helpful if you take an extra step further. That is, you don't just download the winning memorials from that year, but you also download and try to read the compromise of that year. And then you try to analyze and go through the questions and the issues. And then you see how the team have argued it. Because if you don't do it that way and you just directly go straight to reading the memorial, sometimes you don't really have the proper context, and you don't appreciate why that memorial is adjudged to be the best in that year. The other thing you should consider reading is also an introduction to international law. The ILSA website also has a guide on this, and this is handy for you to read, especially because I don't know from which class year you are from when you start out the Jessup moot. When I started out, I had no training in international law. I had to read all the books myself. So it helps if you have a little piece of a guide that can guide you through the basic principles before you start off reading the other larger materials. Other than this introduction to international law note that's on the ILSA website, then you can move on to other heavier textbooks. As I mentioned there, there's a couple that's quite famous, Shaw, Brownlee, Akers, and there's a number of other international law textbooks that are available to read. Next slide, please. This is just a little further from what I was saying earlier. I'm not sure whether the committee will be sharing this slide to you. I hope they will. Basically here, I have inserted hyperlinks to websites where the materials from this presentation are taken. It's really nothing original. I've cut, pasted, and selected things that I think are really the key things from all the materials that I have read to prepare for this presentation. So I mentioned just now, you should read through the Introduction to International Law. That's the first hyperlink. And then there's the Jessup Guide to Memorials from White and Case. I've taken materials from that as well. That's there. And the guide to Philip Jessup International Law Moot, that's very helpful because that contains tips on how to do research, legal writing, and also oral advocacy. So if I were you, I would try to look at all these sources first. Next slide. And another, perhaps, hopefully helpful video for you to watch is this video that I found on YouTube by Nick Friedman. He's from the University of Oxford, and he's done up a video on how to draft legal arguments for your memorials. Granted, his video is not based off the Jessup Moot, but the principles that he discussed in the video is equally applicable in the Jessup Moot. In particular, he will be talking about the way one should structure the memorials, which is using the ILAC formula, which is actually another way of saying the IRAC formula. And I will talk about this more later on. It's basically a way of structuring your arguments in a more logical and coherent manner. So that's the introductory material that I have for you guys. I hope you will take a look at those hyperlinks before you begin. I found them extremely helpful. We can now move on to the next slide. The scoring criteria. So, and we can go on to the second slide as well. Okay. So the Jessup Moot has this memorial score sheet for judges, because today's presentation is about memorial writing from the judge's point of view, how to make sure you tick off those boxes. So this is what it looks like for a judge. They have this sheet, they fill in their name, the team number, total memorial score, and you see down there, there's an optional scoring criterion worksheet. There's 5 boxes there with presumably the same maximum score, right? There's knowledge of facts and law, there's proper and articulate analysis, there's extent and use of research, clarity and organization, and lastly, style, grammar, and citation of sources. Now they've listed this down 1, 2, 3, 4, 5, and if you look at it, you would kind of think, oh, knowledge of facts and law is the most important one that you would have to tick. But if it's the most important one, then logically it shouldn't only be a score out of 20, but actually all those elements have an equal score out of 20. So in the Jessup Moot, actually all these 5 elements are equally important. But the thing is, not all judges really attribute equal value to the box. As you can see, the 5 elements are under what's called the optional scoring criterion worksheet. You will find some judges just prefer to insert the total memorial score and they will insert comments. Sometimes they don't have time, so they don't insert comments at all, and you just have the total memorial score. And then when you look at your score, you could be left confused because you don't know what's the basis for them, giving their scores. When I judge, I try as much as possible to use, and actually every single time that I judge, I always use the optional scoring criterion worksheet. And this is really because I want to have a proper standard for my grades. And I want to make sure, if something is excellent, then it's excellent because, for instance, I think it's a perfect 20. Or if it's just adequate, then it's just adequate. And for me, the guides here, 10 to 20 points, are very useful. But as I said before, not all judges attribute equal value to each box. So if they don't attribute equal value to each box, the question is, which boxes should you pay more attention to, right? And you would think maybe it's number 1 and 2. I have my own views on that. And as I will explain later on in the next slide, I will also explain how you showcase fulfillment of each of these boxes, because even the judges themselves, all they get is this sheet. You know, they don't get another guide or explanation as to what is meant by knowledge of facts and law. They just have this brief pointers of 10 to 20 points: poor, adequate, good, very good, excellent, and perfect. But there's no explanation of what's a perfect score. So I'll try my best to explain how you can achieve an excellent score, or what is meant by just an adequate piece of memorial. Before I move on to the next slide, I'm just making sure that there's nothing I miss in my notes. I had a question when I was preparing this presentation slide, whether there are deal breakers in scoring memorial. And I'm not sure if deal breakers would be the right term for it, but I think if the memorial doesn't read easily, if there's hardly any analysis, if it's jumpy, then I'm not likely to want, as a judge, to continue reading further. And I will explain also what I mean by this in my next slide. If we can move on, please. So the memorial has to consist of these things: cover page, table of contents, index of authority, statement of jurisdiction, questions presented, statement of facts, summary of pleadings, and the pleadings itself. If you look at the Jessup rule, they will explain further what each elements mean. And if you look through the, I think, White and Case guide that is in one of my hyperlinks, you will also find an explanation as to what each of these mean. But the key thing that I wanted to say here is that you have to make sure that your memorial has all these things in it, because if I'm not mistaken, if you don't have these things, you can lose points. And if you add things to it, you can also lose points. And you don't want to lose any points. So make sure, this you have all 8 things in your memorial. In the next slide, I will be talking what makes exceptional legal writing and try to explain the elements of the scoring sheet that we have seen earlier. So next slide, please. And we can jump to the next slide. Okay. So what does it mean when a legal document is well written? I had, in one of my earlier slides, mentioned the definition of a memorial, and I highlighted the importance of the audience. And the reason I did that is because your memorial is there for a purpose. You write the memorial to persuade the International Court of Justice to make a decision in your favor. Putting aside the Jessup context, in the real world, a legal document is well written as long as whoever is reading feels that the thing that they are reading is beneficial and it will help them make a decision in the course of their professional duties. So, whether you are going to be a judge, or if you are a student and you are writing for your professor, or if you are a lawyer and you are making a memo to your senior associate or your partner, basically your document has to help the person reading make a decision. And again, putting this back into the Jessup context, it means if you are writing for the applicant, your memorial is going to win the applicant's case, or it's going to win the respondent's case. Now, the 3 things that any legal document should do is it has to be clear, it has to be concise, and it has to be engaging. Now, what do I mean by each of those elements? If we can turn to the next slide. Clear, concise, and engaging. Clear means your language cannot be complicated. you can't have jargons. Jargons as in, there's a lot of legal Latin jargons that you will learn, pacta sunt servanda, a lot of Latin terms that we would come across when you read your books. But a good memorial will do away with all those complicated language. Plain language is always preferred. Plain language meaning, as much as possible, you are using words which does not require the reader to get a dictionary and open the dictionary to understand what is meant by that particular word. Some might argue, does that mean that it's overly simplistic? But actually, no, because the goal for you should always be to explain your arguments in the most simple way possible. And you can't do this if you use overly complicated words. So, and I've read a ton of legal writing books and they all say the same thing. Plain language is vital. The other thing in clarity is obviously you need to have proper grammar. If the order of your sentence, your subject and object is all over the place, or it's missing a subject or it's missing an object, then you can't really begin to try to comprehend what you are trying to say. The other thing is logical structure and punctuation. I think punctuation goes without saying. If it's missing a comma or a full stop, you can have run-on sentences. But when you get to this stage as a law student, I think you already know the value of punctuation. As to logical structure, one is not likely to want to listen to somebody whose words have no logical structure, because to use the phrasing bahasa, nggak jelas kemana. So you need to have logical structure, and if you have logical structure in your writing, you have clarity. And again, as I've put there, a quote by Brian Garner, the reason is because at the end of the day, your goal is to communicate, and you want to communicate as clearly as possible. So moving on to concise. Concise means the meaning that you are trying to convey is conveyed succinctly, without unnecessary words. That's what superfluous means, and with an appropriate level of detail. So sometimes when you type, or when you initially start out to write your sentences, you don't edit. You just go on to type whatever's in your brain, and it goes on the paper. And therefore, you may end up with more words that you use, or missing words. So the key that has to be kept in mind is when you go on to edit, because there's no such thing as a perfect first draft, you try to find words that you can actually delete from your memorial and sentences that doesn't have to be there. So if you do this, you will be able to achieve, hopefully, what is a concise piece of writing. Now, the last thing that a piece of memorial should do, and any piece of writing should do actually, is that your memorial should be engaging. It means you want to keep reading the document. No matter how clear and concise your document is, if the memorial or your writing isn't alive, you're not really likely to want to continue reading. Why is this such an important thing? It's because the judges are very busy people. Take my experience for example, because they all work, they either as lawyers or something else. And they take free time, from their very busy schedule to read 4 or 8 memorials, however many they have agreed to review. And I've come across very confusing memorials, or memorials which I feel are just lazy pieces of writing. And initially on the first page, I look at it and then I would be like, why am I reading this? Why do I even want to continue the second page? Sometimes I tell you, the judges won't even continue going through all your argument. And that's a shame, because I think sometimes your best arguments could be written in the 3rd or 4th section, because sometimes maybe, it's written by a different person, or maybe you just were able to flesh out your arguments in the 3rd and 4th section better. But you can imagine a situation where a judge doesn't even bother to go towards that stage when, the judge just decides, okay, I've had enough, I'm not going to be, reading anymore. So you have to try as best as possible to be engaging when you write. Okay, so if you can move on to the next slide. Okay, proper and articulate analysis. If you could jump back to slide 10 for a minute, I want to show you what I mean. Slide 10, sorry. So just 5 more slides, which is the scoring sheet. Okay, great. So I am starting out with number 2, proper and articulate analysis. And I start out with proper and articulate analysis because I feel, for me, and perhaps other judges, this is probably the most important box that you need to tick in a Jessup memorial. For me, it's not knowledge of facts and law. For me, you begin with proper and articulate analysis because if you do proper and articulate analysis, actually, you would also tick number 1 and number 3 at the same time. And I'll show you what I mean by that. So if we go back to slide number 15. Why this is the most important thing, in my view, is because when you properly analyze the compromise or the prayer of relief, you spot the right issues. And it means your argument is going to be fulsome. You will have identified the things that you need to argue. The judges in the Jessup moot have what's called a bench memo. And the bench memo tells the judges the kind of arguments that the team should be coming up with. It's not the end, to the arguments. It doesn't mean that the team cannot come up with arguments outside the bench memo. But more often than not, the judges would use the bench memo as a guide, as a standard thing by which they will adjudge your memorial. If you don't argue certain things that's not covered in the bench memo, chances are you're not going to get very far in your scoring. So you need to be able to properly analyze the issues that's going to come across in the Jessup memo. And the first thing that you do in order to do this is by reading the prayer of relief. You can, if you start off from the first paragraph to the end, you can also do that. But for me, if you want to cut through and be more active as you read the compromise, is if you read the prayer of relief. It's kind of similar if, for instance, you come across a really thick book, whatever book it is, maybe a novel or one of your legal textbooks, and you don't have a lot of time. Say you're crunching through time, you only have 2 days or 3 days to master something. What do you usually do? Do you go through page 1 to page 30? For me, that's not what I do. I actually go through the table of contents and I look at the most relevant chapters that I need to read. And I would go to that chapter first. And I keep this chapter in mind as I then read the book. Or if I'm trying to work through a piece of memo at work, I will keep in mind the questions that are being asked. And as I do my research, that question is at the back of my head whenever I do my research. So I'm not lost. So if you read through the prayer of relief first, before you read through paragraph 1 of the compromise, you will know, oh, there's 4 things or 4 issues that is being asked that year. And as you go through the compromise, it will kind of jump out at you, the words in the prayer of relief, and you will start to kind of brainstorm immediately. Oh, this goes to issue 1, or this goes to issue 2, this goes to issue 3, and again, this goes to issue 4. So it just kind of makes it more effective for your reading, I feel, if you read through the prayer of relief first. So yeah, so that's why go read the prayer of relief first before you read the entire compromise front to back. Next slide, please. The other things you should do in order to be able to properly analyze the issues in the compromise is you identify the keywords in the pleadings. So if you've firstly looked at the prayer of relief, you would be able to know which keywords in the pleadings should be addressed, or the legal terms of art that will arise. So terms such as, for instance, here in the slide, there's attribution, there's hot pursuit, there's aggression. These are terms of art legally. There's proper legal definitions. And if you do a legal research, it will tell you, what these words mean. And for instance, for attribution, what is actually meant by attribution? How do you attribute the act of somebody or something to a state? And your research will tell you where to go and look for the relevant cases for this, and then you will be able to apply it to your case. The other thing is you compare the wording of the same issues between the applicant and the respondent. There's a question here: have you ever wondered why the choice of words in the applicant and the respondent's prayer of relief are markedly different? And that's because the prayers must be different, but sometimes the terminologies are different. And the reason for that is, for instance, if the applicant wants it to be a violation, the respondent will not want it to be a violation, but they will use certain words that maybe can excuse that kind of violation under international law. So you should be careful when you read the prayer of relief in the applicant and the respondent side and notice why they are not the same. So for instance, here, there's two examples there. If the applicant uses the word conduct, the respondent uses acts and omission. So here, for me, when I read this, the applicant maybe want to try to hide the acts and omission as just a conduct, as being an acceptable conduct, but the respondent will be arguing it's a proper act and omission in violation of international law. So pay attention to those differences in keywords in the prayer of relief, and see how that could apply to the compromise. And by the way, while I'm at this slide, you'll see that this is number 16 and 17. The reason why this number 16 and 17 is because I've taken this off the, in one of my previous slides, there was a screenshot of a page of the guide to the Jessup moot. So this is taken from that document, and I've basically, plucked out the bits that are important from it. Next slide, please. Now, if there are two sub-issues in one issue, you should also bear in mind that the two issues may or may not be independent to each other. So if you look at this sentence in the box, there's a sentence: a violent killing in a town occurred and the ensuing prosecution of the perpetrators. You would think that these two things could be separate, or it could be conjoined. Here, what is trying to be told is that actually you don't really need the word ensuing, but when you read it in the compromise, it's as if the drafter of the compromise is trying to attach something more to that word prosecution. It's as if they want you to think, oh, the prosecution followed from the violent killing, but it may not have. So that's another way for you to really properly analyze the compromise. Pay attention to how the sentences and the words are linked together. The last thing that could help you to properly analyze an issue or the Jessup compromise is really to go back to your textbook and use that as a checklist of possible issues that may arise. Because after you've gone through the prayer of relief key terms and also the compromise, there may be other things that you may be missing. And if you haven't studied international law previously, you won't know them. So you go through the table of contents and just look at the possible issues that could be addressed here. In the next slide, please. So here is the prayer of relief for the applicant and respondent from the Jessup Compromise 2007. Here, there's not a great world of difference. Actually, it's largely the same. The only difference is that for the applicant requests the court to adjudge and declare that there's this law called the National Industry Act, does not constitute an illegal expropriation of Adar Moi. That's a company. in the compromise and the other practice concerns under international law. And on the other side, the respondent is just saying that that constitutes instead of it does not constitute. So here, if you look at the compromise, the issues are the same. One wants to say it's a illegal expropriation, and the other one say no, it's not an illegal expropriation. Now, in the next slide, which is tied to this prayer of relief, if you could go back to the previous slide again. So here, what is wanting to be proven is this issue of illegal expropriation. Is there illegal expropriation? Is there not illegal expropriation? What is being expropriated? You have the sentence "Adamoir and other practice concerns," right? So if you look at the prayer of relief first and then you go back to the compromise, what you end up doing is, as you'll see in the next slide. Next slide, yes. So you see, so there's paragraph 35 and 36 of the compromise. That's the National Industry Act. It's a law forbidding the exportation of the proceeds of the sale of goods or services produced by certain recently privatized business concerns. What I would do is I would look at, okay, expropriation, and then it mentions the National Industry Act. So one of the things that I would be looking for when I do my research is National Act and expropriation. Why? Because I would want to ask myself, can an expropriation occur by the passing of an act? If you've studied contract law, you may be familiar with the term force majeure or an act of God. And how that is relevant is sometimes there would be clauses in the contract which says the passing of a law is not a force majeure. So similarly here, is the passing of a national act an act of expropriation? So that's one of the things I would research, and I would want to find whether there's any other countries that have previously passed similar legislations, and whether the passing of those legislations have been deemed by the ICJ to be an act of expropriation under international law. Other things you can research, from the compromise is not just expropriation, but also break that again to illegal expropriation. So there's a difference, because not all expropriation is illegal, and that is why the word in the prayer of relief is illegal expropriation, because under international law, certain acts of expropriation are okay, provided you fulfill the elements of expropriation. So if you don't know this, if you don't pay significant attention to the word illegal, then you won't know what acts of expropriation are supposed to be illegal, right? So that's why paying attention to these words are really key. The other thing that I've picked out here is capital flight and expropriation, and then prohibition of exportation. Basically, I try my best to tie up specific terms or phrases in the compromise with the thing that's being asked by the prayer of relief. And that's why when I research, it's expropriation and international law, and then national act and expropriation. And these are in quotes because that's literally how I would actually put my search terms on Google or on Lexis or on Westlaw. That's how I would put, my research terms as. It's not just the random words without any conjunction, because that will make my search terms far less effective. So once you've gone through this exercise, hopefully you will be able to properly analyze all the proper issues, or in other words, you will be able to spot the right issues that should be addressed by any prayer of relief in the Jessup Compromise. If we can move on to the next slide, please. So what's articulate analysis, which is the second part of that box in the Jessup Mood? I have here 3 words which I've taken off Google Translate. Articulate means you are able to speak fluently or coherently. Fluently means it's smooth, and then coherent means it's logical and consistent. So keep this in mind by when you write, this is what you kind of need to achieve, and what is meant by articulate analysis. Next slide. How do you articulate properly? You articulate properly if you do three things. One is you avoid unnecessary arguments. Two, you avoid repeating the facts in the pleading section. Three is if you address any weaknesses in your arguments. Why these three things? First of all, again, the goal of the memorial is to persuade the judge. You want them to win in favor of the applicant, or you want them to win in favor of the respondent. So you don't want your memorial to be consisted of a bunch of arguments that are possible to make, but not necessarily winning arguments. You should start off with your strongest arguments, and then as you go through all the potential arguments that you could make, you have to ask yourself, is this argument going to convince the court to grant the relief that is requested? And does it have to be made? What that means is, do you think it's likely to be bought, or is it a nice to make argument, but not really crucial? Do you have the proper support for it? Think through all your arguments properly. And unless they are really, really necessary, I would suggest not to make the argument, because if you have a memorial that consists of strong arguments and then a mix of weak arguments, it kind of detracts from the strength of your memorial. So avoid all unnecessary arguments as much as possible. To avoid repeating the facts, and I will explain this in the next slide. And the third is you address any weaknesses in your arguments. The reason why it's important to address any weaknesses in your arguments is because in the real world, and also the Jessup mood, it's impossible to have a perfect scenario where your client is 100% correct. And the Jessup mood is really not designed that way. Actually, no mood problem is designed that way. It will tend to be equally balanced in favor of both sides in order to make it arguable by both sides. So what the judges will want to see is, in addition to you creating strong arguments for your side, for the applicant or for the respondent, they will want to see whether you have thought about what the other side will say, or if you haven't thought about them. And if you have thought about them, what do you think of those possible arguments? And the best memorials tend to address any possible weaknesses. And the reason why this is really good is because it shows that you have properly analyzed the case, which means all the possible issues that will arise. And two, it will show that no matter those potential weaknesses, you can still win your case anyway, and that those weaknesses don't matter to you, or you found a way to go around it, And usually what you want to have is, when your opponent receives your memorial, is you don't want them, what you want them to do is, when they receive your memorial, you want them to be, oh crap, they've preempted this, oh, they've already addressed this, so they've already left shut when at the first go. Whereas if you don't address this, they think that you haven't thought about it, so it doesn't look very good. And then for the judges themselves, they will kind of think that you either don't know it, or you think you can't win if you don't address it. So make sure that you try to address these weaknesses. This means if there is a negative authority that you find in your research, you mention that and you distinguish it. So if you know for expropriation, for instance, this is the case that's applicable, and you know that there's certain elements that you don't fulfill, you can explain why that case doesn't apply, or you can explain whether there's certain facts that are different, so that, again, the case doesn't apply. So just mention and distinguish whatever negative authority there is. Now, if the law is not on your side, again, other than distinguishing the case, what you can do is you appeal to equity. What that means is you try to appeal to the judge's more human side of things, the political side of the issues, and try to catch it as okay, yes, we understand this was illegal, but it was an understandable action because why? It was reasonable in the circumstances because why? Because the issues are human, and the judges want to see how, even if the law is not on your side, maybe factually there's things that would allow you to get away with that. The other thing is make strategic concessions. What does this mean? It means if you know a point is not going to be won, don't address it. As what I mean by don't address it is not by not mentioning it at all, but by saying, yes, you know of this issue, but this issue is not relevant, and then you explain why it's not relevant. Or if you choose to not address it, what you do is you cut through the chase. So in the example of expropriation, instead of going on explaining about expropriation, you jump straight to, in this case, it is not an illegal expropriation. So you cut through the point that there is an expropriation. You don't argue with the other side. Yes, okay, we agree there was an expropriation in this case, but in this case, that expropriation wasn't illegal. And the reason why this was important is because sometimes you still have teams which explains lengthily this bit on expropriation, whereas actually you could totally cut that away and make space for your other arguments if you concede, yes, okay, there's this expropriation. And the last bit I think already covered previously. Basically, you clarify when a different rule applies in different situations, so that, you know, if you have a law that basically doesn't apply, or it should be applied, then find why in that case it doesn't apply because of the different situation. If we can move on to the next slide. Here you have, this is from a different year, the left side and the right side. If you look through this, the question here is, which is the better drafting? And I've selected this as an example because in the left slide, or in the left box rather, it contains a few unnecessary sentences and facts, and the right one is more concise. So if you look at the left one, Thomas Good was one of 100 Raglanian citizens selected and trained as pilots as part of an anti-piracy program run by the Raglanian government. If you look at the box on the right, the writing is more direct. It jumps straight to saying Thomas Good was clearly acting as an agent of Raglan when he boarded the Mairi Maru, which is the ship, since he had been selected by the Raglanian Royal Navy to pilot the ship and boarded the ship under the ostensible authority of the Navy. So what I'm trying to show here is the first sentence and the second sentence in the left box can actually be paraphrased or combined into this one sentence that you see on the right box. The fact of him being one of 100 Raglanian citizens is a nice fact to know, but it's not necessary to have. You just pick the fact that he was trained as a pilot and he was selected, and that's why he was acting as an agent in this case. So, you know, as you draft, make sure that whenever you're drafting like the one on the left, how can you transform it to the one on the right side? So I hope this explains what is meant by proper and articulate analysis. If you move on to the next slide, this is about knowledge of facts and law, which in the scoring sheet appears to be number 1. For me, after you, like I said before, if you properly and articulately analyze the issues, you will automatically tick this facts and the law box. So here, I've set out Article 38, paragraph 1 of the statute of the ICJ. And why this is relevant here is because the judge, when they read your memorial, they will want to know whether you know the hierarchy of the law, which laws are relevant for you to cite, to look to, and which laws are binding, and the precedents in each of those laws. And basically, most people agree, the prevailing view is that this sets out the hierarchy of importance. When you write your memorial, the treaties should be firstly cited, and then any cases or state practices, and then you can refer to decisions or writings. It shouldn't be, you shouldn't be citing the book first. You should be citing the treaty or the customary international law in that order first. So with this box, you need to show that you know this hierarchy, you know that you need to be referring to these sources of law in this order. And if you can move on to the next slide, other than knowing the law in that order, basically you need to show that you are using the facts relevant to the law and vice versa. And if you do that, then you can show that you do fully appreciate the relevant and favorable facts to your side and how the law applies to that. If you look at the next slide, okay, this is kind of tiny. So, if you finish the session and you go away on your own, you may want to digest this a little bit more. The left side is not a very good drafting. If you look at the first sentence, Mauritania fulfilled its obligations under international law. And then, according to Article 56 of the UN Convention on the Law of the Sea, Mauritania has the right to establish artificial land. And then the next sentence is, and the construction process fully complied with the terms of the Malaki Gap Treaty. So there's a jump here in the logical flow. The first sentence is trying to say that the state fulfilled obligations under international law. The second sentence tries to explain the relevant law applying to that obligation, which is Article 56, and which is that you can establish artificial land. And then the next sentence is the construction process. So you just jump straight away from you can establish artificial land and then the construction process. There's a jump there because you're not clear what construction process of what, you see, or of the land, or it's not clear. And then, moreover, Mauritania fulfilled the cautiousness duty before establishing the island. So if you look here, the second sentence, according to Article 56 of the UN Convention on the Law of the Sea, you have a right to establish artificial land. And then as part of that right, what you have to fulfill is the cautiousness duty. But the way that this is structured is jumpy. The fourth sentence beginning, moreover, Mauritania fulfilled the cautiousness duty, should appear after that Article 56 of the UN Convention of the Law of the Sea. So if you compare actually to the one on the right, this is a much better way of explaining the law and how it applies. If you look at the right box, it says, under international custom, the obligation of due diligence requires an environmental impact assessment to be conducted when there are reasonable grounds to believe that activities may cause significant transboundary harm. What is meant by that precautions, right? That's further explained. And then it basically, the right box go on to further explain what is meant by an EIA, or that environmental impact assessment. And then it goes on to apply, in this case, Excelsior Island dredging required that assessment, not only because it was harmful, but also because it was reported to be environmentally harmful. So I hope by comparing these two boxes, you can understand, when there's a jump in the analysis, and how you should be able to showcase your knowledge of the law, and also like applying the relevant facts. And the next slide as well will try to show that, if you can move on. So here, this is another year from the JESUP. I think maybe this was recently this year. So here, the first sentence is, taking of the yak is supposedly an endangered species, is permitted under Article 3(5)(d) of the relevant convention if there are extraordinary circumstances. So the first sentence tries to explain to you why the taking of this endangered animal is okay under international law, and it's okay when there are extraordinary circumstances. Now, the second sentence tries to explain to you that that there are indeed extraordinary circumstances. It's for the good of mankind. And then it explains again, that Galvectra, which is the reason why the yak was taken, is an essential medicine. And it's actually recognized as a fundamental human right. And therefore, the taking of the yak is permitted because there are extraordinary circumstances which justifies the taking of the yak. Yeah, so additionally, the word require. And if you look at the last sentence, that really kind of emphasizes why, in this case, the state really had to take the yak, because there's no other way for them to get this medicine for the benefit of humankind. If we can move on to the next slide, which is statement of facts. So there's certain questions here that I received, whether the statement of facts could be drafted in a more efficient way and how that could be achieved. So this thing that you see here is taken from one of my the other guides that are hyperlinked. Basically, there is definitely an art to telling the story in the statement of facts. I had a question whether one should start with dates or we should start by topics. And my suggestion would be to break down the facts into relevant topics. And this is because even in real life cases, when you explain the relevant facts to the tribunal or the judge, you want to set it out in a context. So this event happened, and then this event happened, and then this event happened. Whereas if you only have a summary of facts or statement of facts section, which is consisting of dates, on this happened, on this happened, you don't really see the bigger picture of things. And it's quite difficult to kind of pick through the most relevant facts that might be applicable. So I would suggest to break down your statement of facts into the relevant topics and pick out which ones should be there, because not all the things that are in the compromise need to be regurgitated in the statement of facts. The thing here that I've said on the left column is tell a compelling story. And this is because a good statement of facts will definitely demonstrate to the team, to the audience, that the team has really thought about which facts are useful and how to present them in the most best manner for the audience and for their case itself. Again, if you find unfavorable facts, just as if you find unfavorable cases, the trick is not to ignore them, but to present them in a way that's okay, or in a way that will make the reader accept that, okay, we understand that there's that weakness in the fact, but we can accept it because so and so. Oh, okay, if you can move on to the next slide. So moving on to the next element in the scoring criteria, which is clarity and organization. A lot of the times I would write on the memorials, and I think judges as well like to say, there's no flow to the argument, you have to have a flow. And this is the box in the scoring criteria that is meant by the flow of arguments. Your argument and the organization of your memorial has to be clear, and there has to be an organization somewhat of your arguments. And this is because, as I mentioned earlier, if it's not logical, if it's jumpy, we can't really follow through your arguments easily, and that's really irritating for the judge and not helpful. Of course, we can do it. As we read, we will eventually understand, oh, you are actually trying to go to this argument. But if it takes too long for us to get there, then you don't really tick this box of a good organization. And there are some tips that have been suggested by some of these guides. One is to really consider the main submissions order. Usually if you look at the prayer of relief, it's 1, 2, 3, 4, and most memos tend to stick with this order. But sometimes there are issues that cut through more than one thing, which is to say sometimes a law applies in 2 issues, and so you may want to kind of actually address 1 and 3 or 1 and 4 first in sort of 1, 2, 3, 4. And this takes obviously discussions with your teammates as to whether that makes sense or not. So the point is basically don't be overly glued by the order of the prayer of relief. Try to consider if there's a better way for you to organize your main submissions. And then you should break your submissions into logical subpoints. We will see this in the next slide, which basically means, if you have your main arguments, what are the subpoints to those arguments? And use headings to summarize your arguments. It means your headings should be useful and shouldn't just be like a word or a phrase, such as they violated international law. You want more than that. You want violated international law because why? Okay, so if we move to the next slide, we can see this. So if you see here, Raglan is responsible under international law for the attack and the wreck of the Mairi Maru. So it's clear that you want the state to be responsible. Why? Because there was an attack and a wreck of this ship. Okay, and there's 3 main arguments here. The first one is the state had breached obligations under international law to suppress and prevent piracy. Number 2 in B is the state is responsible because they failed to respond appropriately in violation of its obligations under international law. And thirdly, the state is responsible because the acts of this person, Thomas Good, are attributable to Raglan. So if you notice here, arguments 1A and 1B is about the state's act, and argument 1C is about the act of this individual person, which is attributable to the state. So that's a different argument. You see, it's not all linked, as in they're not the same ones. And if you look at A and C, there's further explanations or breakdowns, or to use the phrase in the previous slide, logical subpoints. So for 1A, you have the state breaching obligations under international law to suppress and prevent piracy. And that's because, number 1, the act fall within the definition of piracy. 2, the state has this obligation to respond to the attack, and they didn't, right? So that's one example of the use of headings so that they convey what your argument is and not just the general topic of the section. And if you do your skeleton like this, then it's already clear when I look at the table of contents of the memorial, oh, this is where you are heading. And actually some judges sometimes just look at the table of contents and then they look at the bench memo and see, oh, okay, you've ticked this. So it's important to get this skeleton in a way that is clear and organized. And if we can move on to the next slide, this is also shown. Next slide, please.
I'm very sorry to cut, Mbak Hana.
Yeah.
I'm just mindful about the time.
Okay. What time is it now? Okay. How many more can we have?
It's up to you. You can. I've checked with Yogi, and from our side, we're flexible about the time. But
Okay.
if you need help to wrap it up in 15 minutes and 20, we can transition to questions and answers for the rest of the material.
Let me
you have in your slides. Whichever you prefer is all right, because anyway, this is a recorded session, so even if the participants can't stay for the full duration,
okay,
we can figure something out.
Okay, then I'll try to finish in the next 15 minutes, hopefully. There should be some slides that I can skip, and then we can move on to questions.
All right, perfect.
That sounds great.
Okay, cool. Thank you. Sorry about that, guys.
It's okay.
Okay, So if, okay, so this slide is basically another example of what I feel is a proper skeleton. I hope I don't need to explain overly long on this. Basically, you just need to read it in order to understand why this is a good skeleton. Basically, it's because all the sentences are proper in that they explain the argument very well. So if I move on to the next element, which is extent and use of research. Okay, so the other box that you need to tick is the extent and use of research. We can jump through to the next slide. So what you need to show basically in this box is that you have considered all these things that you see on the screen: treaties and conventions, resolutions, cases, international or municipal, books and journal articles. And the reason is because one of the things that has to be in your memorial is called the Index of Authorities, as you have seen in the one of the previous slides. That's one of the things you have to have. And most judges will just look at the Index of Authorities to see whether you have considered all these things, you know, whether you are citing treaties, or whether you are only citing from books, or whether you are only citing from cases. It's immediately clear from the Index of Authorities page whether you have performed an extensive research. So if you look at the next slide, that's an example of an Index of Authorities. Sometimes the teams won't organize it like this, but I would recommend that you do organize it like this because it follows the hierarchy of Article 38(1) of the statute. Also, if you look here, you know, under A, B, C, and D, it's organized in an alphabetical manner, and I think it's just more easy on the eye to read it that way. You don't have to organize it alphabetically, but I think most teams would try to do it this way because it's just easier to read. And if you want to, you know, find, oh, this convention, if it's not ordered in alphabetical manner, it might be, you know, kind of hard to find. Okay, we can move to the last section in the scoring criteria, which is style, grammar, and citation. Style is something that takes practice. And the thing that's important here to note is when you are working in a team, you know, on your memorial, there would be obviously usually more than one writer. That's my experience. And also some of the teams I've coached. Actually, I don't know any team where there's only one writer, but kudos if there are. But usually you would have more than one drafter for a memorial. And you know, people have different writing styles. So you want to make sure that the language throughout the memorial is consistent. That's what's meant by, you know, style. You don't want it to look as if there's more than one person writing. And let me tell you, the judge will be able to tell if it's not like the same person who's writing it, because your style kind of, it just jumps from the page. The other thing you should consider when it comes to language is that you need to ensure that, you know, the grammar, syntax, and voice is consistent. Your sentences should be short and punchy. Again, as I mentioned in the other slide, you need to use plain and active voice. And if you do use conjunctions like moreover, in addition, therefore, thus, and various other conjunctions, you only use them when you really need to, because more often than not, you have those words as a gap filler and they don't really need to be there. So pay attention to that. Next slide. That's just another example of a memorial. I think I won't cover this very much. If you read it very carefully, hopefully you'll be able to understand why, again, this is a good example of writing. I will just want to address one thing as regards style here, which is the IRAC or ILAC method. So the Oxford video in one of the earlier slides talk about ILAC, and they use ILAC because they say issues, law, application, and conclusion. The American version is IRAC, which is issues, rules, as opposed to law, application, and conclusion. So it's the same principles, it's just different terms. And what that means is, if you look at this, for instance, on the right column, number 4, that's the issue. There's an issue of whether the act is illegally expropriated by the state. And then the A goes on to explain, the A is also the issue, which is why it constitutes an expropriation or not. And then if you look at the paragraph, you go on to explain the law or the rule. So the law or the rule is that, expropriation will happen, not limited to states' direct taking, but why? And then again, you explain the law when you refer to the case. And then if you go all the way down, that all explains the rule. If you go to the very last sentence, to determine whether a governmental action is expropriation, tribunals will generally consider number 1, number 2, and number 3. So after you explain this rule, then you begin to apply why the National Industry Act in that case does not fulfill or fulfills those elements that you have just explained. And then you conclude your argument. Once you've read more than one memorial, this kind of style becomes clear and you will be able to follow it. The next slide, please. So this one is not a structure of the pleading, but it is a structure of the questions presented, because that's another thing that can make your memorial really stand out. Most often, the teams will just use formulas such as whether the act is an expropriation, whether this is a piracy, whether. Basically, they use the word whether a lot. But if you try to formulate your questions presented like the one you see on the screen, it's a lot more clear, you see. Has Pandemilia breached its obligations? Notably, what is the obligation? The VCDR, which is the Vienna Convention on Diplomatic Relations and Customary International Law, by searching and attaching the premises. And then the question following after that is, or part of that main question is, does the building itself constitute premises of a diplomatic mission? And the question is, under number 1, is the building used for mission purposes? So if it is used for mission purposes, then it would arguably constitute, part of the premises of the diplomatic mission. So you see here how this type of questions presented is more effective than the usual whether, because whether doesn't really tell you all the sub-issues that could be asked in a particular question or prayer of relief. So I would go against recommending, in your questions presented, to simply paraphrase the prayer of relief into a whether formulation, but try to kind of break down that prayer of relief by this question. And one way to do this is actually by converting your skeleton arguments or your table of contents into this kind of question. So it's not actually that hard. Just takes a bit of tweaking here and there. But I feel this kind of questions presented is far more impressive than the usual whether formulation. Okay, next slide. That's just another example of a skeleton, so I don't need to talk about that one. Next slide. Now, the other question that I had was, sometimes English is not your first language. Maybe for a lot of participants, that's not a first language, and how do you deal with this? Unfortunately, spelling and grammar mistakes should be avoided as much as possible. And so I can understand that if English is not your first language, it could be more difficult for you to try to correct this. So the solution to that really is just more reading, more hard work. If you ask me whether it's perfect grammar, I wouldn't know, like whether it's a syntax or what, because I learned through reading a lot of novels. So I would be able to instantly recognize, just by reading several sentences, instinctively how that should be phrased, or whether grammatically it's incorrect or correct. But I wouldn't be able to tell you, what the name is technically, grammar-wise. Like I wouldn't know how to do that. So I would really recommend for all teams and participants to really read as much as they can, whatever English materials that they can find, either that's poems, novels, go for it. There's no limits to what you can read. And you should also practice speaking in English, which is something that I did when I was a participant. My coach basically forced everyone to have practice sessions in English, and it's only when you really can't express something in English that you resort to Bahasa. But otherwise, you try as much as possible to speak in English, because this will also train you to think in English, which I think for the most part, if you don't have English as your first language, you still think in Bahasa in your head, and then you end up translating. Whereas if you're used to speaking English, when you think, it's also in English, and it will also help you when you go on to the oral stage, because you automatically come up with answers in English. If you go to the next slide. So here is something that I found online. I would really recommend you to read it. It's an article by William Zinsser, who wrote on Writing Well, which is a really popular book on writing. Not legal writing, by the way, it's just a general book on writing. And it tells you how he feels, a person who does not have English as a first language should approach writing English. So try to Google this. I find it to be a really interesting read. Next slide. So the next two slides are from my Kindle. As you can see, I read a lot of legal writing books, and this is just some of them. The Art of Advocacy from Noah Messing is really recommended. The Lawyer's Guide to Writing Well. Basically, there's no substitute to reading and reading and reading. If you Google online, there are several authors which you may want to look up. Brian Garner, who is the author of Plain Writing in English, I think, and several other books, such as The Winning Brief. I'll just show you here. It's this book, okay? It's really, really good. If you can get your hand on a copy of it, I would really recommend it, because he shows you a lot of examples on thick paragraphs and then how to cut that down to size. Other than Brian Garner, you should look up Ross Guberman, who wrote Point Made, actually, which is this book. And it tells you how to write like the top advocates in the US. Unfortunately, for some reason, I don't tend to see a lot of English authors on this topic. Most of my sources are from the US, but they're all very good reads. So that's another book that you should read. And from this list, what I would really recommend is the last one there, which is Legal Writing Nerd B1 by Wayne Sheese. Why this one was really good is because he actually kind of summarized the points from Brian Garner and Point Made in a way that was really easy to follow. So that's one book I would really recommend. If you look at the next slide, that's okay. Other books basically on my Kindle list. Show or Tell. That's something that sometimes you may find as you try to research what is good legal writing or what is good writing. How do you make sure that your sentence shows instead of just telling something? And you may not need to buy this book. I think there's various articles online that you could look up as well for this. So if you could go to the last slide, I think, or second to last slide. So yeah, I've mentioned, sorry, the previous slide. Yeah, so Richard Wydick, Plain English for Lawyers, that's a good one. Baragana, I just showed you that. Joseph Williams Style, Lessons in Clarity and Grace, that's downstairs, that's not here. And then this article from Mark Osbeck, What is Good Legal Writing and Why Does It Matter? That's the link there. And that's where I got the thing that I said earlier in this slide, why a writing has to be clear, concise, and engaging. And he explains all these three things very well. I hope you take my point already from attending this presentation, but if you want to read up more on it, then please go ahead and click on that link. And there's another link there on how to write good. That's also very helpful, which I think will tell you, if I'm not mistaken, it gives you a list on phrases that you need to cut, such as in order to, in addition to, basically other phrases that one would commonly insert in a memorial or piece of writing and can actually be deleted. So it's a very handy reference to have. And last slide, I think. So last but not least, citation is important because your arguments should have footnotes. Why should your arguments have footnotes? Because it's very rare that you come up with an original thought on your own. Most likely, there's already somebody somewhere who have thought about it before. If you do your research, obviously it's going to come from somewhere. So you need to properly attribute. And if you don't do this, you are in danger of plagiarizing, and plagiarizing will be penalized in the Jessup Moot. It's in the Jessup rules, if I'm not mistaken. And the judges or the whoever's grading it sometimes would actually try to, if they see a sentence that's particularly funny or they have questions about it, they can type in the whole sentence on Google and then they realize, oh, it's actually a cut paste from something else. And that's embarrassing and you don't want to do that. So, if you want to use any sentence, go ahead and use it. Just make sure that you attribute the authorship of that sentence properly, so that you're not, going to be convicted of plagiarism. And then the other thing that's important is for citation, you should avoid what's called string citing, which means you cite a lot of authorities, 10 to 15 or more, because most of the times you only need maybe 3 or 4 cases. And maybe as you see there, the only justification why you want to cite that many is when you want to state practice, but otherwise, try to get the most applicable law, the most recent ones, and the most relevant quotes from textbooks or journals that you can find. It doesn't have to be everything that you put in there. And another reason why you want to do this is because there's a word limit to the Jessup Moot, and if you oversight, you lose space that you could otherwise be using for the substance of your arguments, which is a shame. You want most of your space to be in your arguments instead of the citation. So keep that in mind. The last thing here is that, again, the key is to apply the source of law under Article 38. That's how the footnotes should look like, with you citing the treaties or the cases and any other state practices, and then you follow with the books and other writings. So I've concluded my slides. If there are any questions, I'll be happy to take them on.
Thank you very much for that insightful presentation. As I said, and as Bahana said before, the participants here are very lucky to be able to attend and have this presentation, because just speaking from experience, I wish I had these tips given to me and this sort of advice given to me when I first started out writing memorials and participating in the Jessup. So now we get towards the questions and answers section of our webinar. If you would like to submit a question, please do so within the Q&A box in the Zoom webinar. And while we wait for participants, if they have a question, to submit it, I would like to ask my own question. And that is, you mentioned earlier about the IRAC structure. So issue, rules, application, and conclusion. But is that structure really rigid? And can there be some flexibilities? Because in my experience, when I read memos from, English countries such as Australia, New Zealand, they're not really following IRAC too much. So if we do want to, be flexible with that structure? Is it possible, and how can we do it?
Okay, before I answer that question, I want to clarify. When you say they don't follow IRAC, what do you notice that they do in the memorials that's different from following the IRAC?
What I noticed that they do is that they combine certain aspects. So issue and application, they do it in one very concise sentence. And as from my experience, okay, I've tried doing that, but haven't really succeeded in it. So do you have any tips on that?
Yeah, okay, so if you go to, maybe the best way is for me to show one of the skeleton slides. Hang on. If you go to slide, right now. Okay, if you go to slide 26. Just to be clear, again, IRAC or ILAC, the general suggestion is to go with the issues first and then the rules. And then just now, your question is whether you can combine the two. If you look at this slide, alternatively, extraordinary circumstances require the harvesting. So for those of you who are not familiar with the memo context, so in this year, what happened was, and I need to explain this so that you understand better why this paragraph is good. So what happened in that case is there's this creature called the yak, which is an endangered species, and a part of the creature was taken to be used as medicine. And the other side is protesting against this act of, taking off this creature to take the medicine because they are endangered and should be protected. And the act of taking them is in violation of international law. So here the writer of this memorial is trying to argue that they were allowed to take the creature, the yak, because there were extraordinary circumstances. And if you look at this heading here, extraordinary circumstances required the harvesting. So they actually combined issue and, it's not, they're not using the issue here. They are using the formula conclusion, rule, application, and conclusion. So the heading is the conclusion. Why the harvesting was okay. It was okay because there were extraordinary circumstances. So the paragraph underneath that tries to apply the other elements, rule, application, and conclusion, right? And the rule is if the taking of the yak is okay under this convention, Article 3(5)(d), if there are extraordinary circumstances. And then they combine that rule with the fact, which is the CMS's purpose of conservation is not an end in itself. It is for the good of mankind. So they are trying to link the fact that under the law, there are certain situations which allow you to take this creature. And this situation is the fact that this is for the good of mankind, right? And so the words extraordinary circumstances, if you see the third sentence, should be interpreted in that context. And then they explain again, the Galvectra which is the end product of this creature, okay, is an essential medicine under the WHO list. And then they go on to explain healthcare and the availability of essential drugs is a fundamental human right. So, and then they apply the fact, whereas Galvectra saves countless lives and is particularly relevant to the state, Rakab is the state, where there is a high diabetes rate. And then they conclude, therefore, the medical advantages are extraordinary, are an extraordinary circumstance. So that's how you kind of mix things up. I'm not sure if it's correct for me to say there's always a perfect way of combining things. Again, as I said, writing these things do take practice. But for me, you just go back to common sense. Generally, your heading has to make sense. It has to be a proper heading, whether that's an extraordinary circumstance that required the harvesting, or whether you are talking, as again in the previous slides, about an act of piracy or an illegal expropriation. Just make sure that when you then have the next sentences, like if it's a rule, make sure that first, for instance, you have a citation to a convention, and then you follow that citation to the convention with case law, and then maybe for an added emphasis, you add writings of scholars or a book, and then you can apply. Okay, so that's the more, I suppose, rigid way of looking at things. You chunk up all the rule in one paragraph, and then you have another paragraph just for applying the facts to that. But I think what you mean by linking the two together is when you have one sentence, which is the law, like this: taking of the yak is permitted under Article 3.5 if there are extraordinary circumstances, and then you have the next sentence, instead of there being another rule, you see, because what you could have done is taking of the yak is permitted under Article 3.5, and then the other bit of the rule in this paragraph is extraordinary circumstance with exception should be interpreted in the context of blah, 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 blah. But what a writer has done is linked up the fact in the compromise and try to use that, to interpret the law. So that's one way of mixing this up.
Thank you very much for the answer. It seems that we don't have any questions coming in. If I would just like to check again. Here we have one from and she sent it anonymously.
Okay.
If I would just read it. Good afternoon, Kahana. I would like to ask a question in regards with the wording for the memorial. From my observation, I have noticed that there are varying views in terms of defining what a great memorial is like. Having noted that you have judged several Jessup moods, I would like to know which one do you and the judges prefer in giving a higher score? Is the use of elaborative words hyperboles that will sway the heart of the judges, or the simple yet direct to the arguments form of writing?
The second one. Definitely the second one. Again, if you have to use overly complicated words, that requires the judge to open a dictionary to understand what it is. It's not a plain way of writing your memorial. And it's just, I suppose it's impressive in some way, nothing against that, but you kind of want to get to your point quicker, right? So you just use very simple sentences. And if you look at all the best memorials, they tend to shy away from, and what I mean by shy away is stay away from overly complicated words. If you look at the one on the screen before, you can understand basically all those words: extraordinary, circumstances, should be interpreted, fundamental. There's no overly complicated or fancy words that's being used, so yeah, judges, I feel, would appreciate that, and I take that because all these other people that I have been quoting from, Ross Gubberman, Wayne Shees, Brian Garner, all these legal writing gurus, they also do not like overly complicated sentences. Yeah, definitely go with the second approach.
Thank you very much. It seems that there are no questions left, so I would like to once again thank Bahana for the insightful presentation. And now I shall hand it over to Joshua to close the webinar.
Okay, thank you, Yogi. It's been a very informative and interesting session we have today. So thank you, Bahana, for sharing us your point of view and also your knowledge on memorial writing. And thank you once again, Yogi, for moderating today's sessions. I also like to thank all the attendees for tuning in, and most importantly, for staying throughout the sessions. And don't forget to follow and stay tuned on our social media, Instagram at Jessup ISIL for the upcoming ISIL webinars. And of course, for the official announcement of the upcoming 2020 21 JESUP National Round competitions. So thank you everyone once again, and have a good day everyone. See you on the next webinar.
Okay, thank you.
Bye.